Bom, boa tarde a todos, todas. Prazer estar aqui no IBRAC, a gente apresentando aqui o painel sobre fusões verticais, não, fusões não horizontais, né? Temos aqui, então, um tema muito relevante, dado o Working Group, que foi formado aí pelo IBRAC, aqui com as nossas representantes pela Vive, a Adriana e a Perez, né, que fizeram um trabalho bastante denso com vários membros do IBRAC, que foi aí também feito junto com o pessoal do CAD, com a Letícia e com a Daniele, e que resultou aí na minuta do guia, né, que tão esperada minuta do guia. Então, acho que um pouco por esse ensejo, né, que esse painel aqui resultou nessa discussão que a gente vai ter hoje com grandes especialistas aqui, né, do tema. Temos aqui a Letícia, a Amanda, o Michael e o Hans. A gente vai apresentar logo mais os nossos palestrantes. Mas a ideia de hoje, de fato, é a gente colocar um pouco nessa perspectiva, né? O porquê que temos guias de análise e como que eles, de fato, têm sido usados nas análises dos casos de fusões não horizontais. Então, acho que nesse ensejo, né, a ideia de hoje é a gente discutir um pouco como que isso tem sido conduzido pelas autoridades, né, nos casos práticos. Então, a gente vai conduzir o painel hoje em inglês, né, até por conta aqui dos nossos palestrantes de fora. Então, eu vou passar aqui, sem grandes demoras, eu vou passar aqui para apresentar os nossos palestrantes, para que a gente vá ter aqui um painel mais de discussões. Então, vai ser mais de perguntas, mais para a gente seguir aqui com essa dinâmica, e no final do painel a gente abre aqui para perguntas de vocês. Bom, então, without further ado, let's introduce the speakers today. So we have Michael Wiener. Michael is a partner with Step 2 in Johnston in New York City. Michael advises clients across a spectrum of antitrust matters, focus on merger reviews and litigation, resolving government investigation, antitrust issues, and providing strategic counseling and compliance advice. Michael is recognized by Chambers, Legal 500, GCR, and others. And Michael is well known for the thought leader with innovative approach in assisting clients. We also have Hans Zenger. Hans Zenger, he's a head of unit at the chief economist team at European Commission. He holds a PhD in economics from University of Munich and a master in economics from University Pompeu Fabra in Barcelona. Before joining the commission, Hans was a vice president at CRA, European Competition Practice, and he has led the economic analysis in a large number of high-profile merger antitrust cases. So thank you very much, Hans and Michael. And also we have Letícia Versiani. Letícia holds a degree in economics from the University of Brasilia, a postgraduate degree in competition defense and economic law from Fundação Getúlio Vargas, and a master's degree in regulation from London School of Economics and Political Science. She's also a general coordinator of antitrust analysis at CAD. And Amanda Taiji. Amanda is a professor of business law at University of Brasilia, as well as competition, international trade, and compliance. She's a consultant at Pinheiro Neto Advogados in competition, compliance, and international trade. She holds a PhD in commercial law from USP, a bachelor degree in law from UFMG, and a bachelor degree in business administration. So let's start with your panel today. So we're going to talk about the guidelines. So you do have now a draft of the guidelines. So I'd like to ask Letícia, what is the purpose and the scope for the Brazilian new no-horizontal merger guidelines? How close the guidelines are there to the actual and the effective analysis that you conduct at CADE?
It's working?
Yeah.
Yes. So first, good afternoon. It's a pleasure to be here. Personally, it's an honor to be talking at such an important event for the very first time. And especially big to talk about the V+ guide that I'm very proud of to be working on it, because it's not finished yet, but will be soon. I think before I answer your question, maybe it's important to give a little background on the guide. It's been talked about for a very long time that we discussed at CAGI the need of having a vertical guidelines, vertical merger guidelines. So last year, we created a discussion group. It began as an internal group, but we ended up opening it, and IBRAC participated also, gave a presentation. But we had internal discussions. The purpose of this group was to discuss what CAGI had been doing until then, and what was happening around the world in other jurisdictions as well, with how vertical merger analysis was being done. And we thought it would be very important, so the talk evolved, and we saw that the need for the guide was real. It would be important for CAGI, and that we come to the purpose. So I think the first was to structure the analysis that was already being done. So we could have more, that would help the internally CAGI, for the case handlers to know exactly how to carry on an analysis, and also to give transparency to the analysis and predictability. So actors outside CAGI, lawyers and firms, etc., could know what to expect from the analysis. Regarding the guide, so we did it, the group made a first draft version, and then Amanda helped us to structure the guide and also made very important contributions. We put it to public consultancy that ended in October, and we received a lot of suggestions, of comments, very helpful. IBRAC did a very thorough analysis, corrected some spelling mistakes, so we're very grateful for that. But we are at this time, now Daniele and I, trying to compile everything that we received and how to best make it fit in the final version. Hopefully, now it doesn't depend on us, unfortunately, just on us, but hopefully by the end of the year, we'll have the final version. And so the scope of the guide. So initially, actually, I'm going to talk about that a little bit in another question, but we ended up including conglomerate analysis as well. So it started at a V guide and it ended up a V plus guide, but we thought we liked the name. So the first part is just how to define a non-horizontal merger. So it's a very introduction part. And then the second part is the basic steps of analyzing a merger. So there is defining relevant market share. Those two phases are very similar to the horizontal. The one that brings novelty is the third part, that is about analyzing potential harm. And then we explain the structure of capacity, incentive, and effects. And then we talk about possible benefits and list some of the benefits that arise from vertical and conglomerate mergers, and possible efficiencies as well. And then the third part is focused on the vertical integrations, and the fourth part on the conglomerate ones. So that's a very, very general overview of the guide. I think maybe Amanda will talk more about that later. And finally, you asked how it actually will adhere to how do you put it, the effective and actual instruction. Yeah. And I think that's important to point out that the guide is based on what we already do. So we hope it will be very close. The guide. Respect. Yes, so it won't have great changes. We're not doing something that it's impossible to reach. No, we're doing a very practical guide that is to help case handlers and help lawyers understand what we're doing. So I think that's it.
That's very good. Thanks so much, Leticia. And talk about the European Commission guidelines, Hans. Could you tell what is the adhere to the clients, for the parties? Can you just discuss a bit how it's, in the day basis?
Ok. Muito obrigado pelo convite. I'm very happy to be here. I should say in the beginning that I'm speaking on my personal behalf and not on behalf of the European Commission. So many thanks for the question. I think, I should say congratulations, first of all, for the efforts of CAGE and, being on this great process of producing the guidelines. It's a really great endeavor. And I think it's very important for the business community, and it's also very helpful internally. To avoid that you always have the same discussions case after case after case, but you've laid out certain principles that are adhered to, and that people can rely on, both the people who are applying the law and the people who have to comply with the law. I would say in the European Commission, the guidelines were in particular important at the time when they were published 20 years ago, because that was a time when actually the approach of the Commission changed quite a bit. If you look at the old case law from like the 1990s in Europe, it was mostly an approach of, kind of big is bad, which didn't have a very focused structure of defining what is foreclosure and so forth. So I think what the guidelines did at the time was essentially to establish this structure that now also is reflected in your draft guidelines of ability to foreclose, incentive to foreclose, and effect, and to say what is harm and what is not. And since this was such a big policy change towards an effects-based assessment of vertical mergers, I think at the time it was enormously important, to clarify things for the people applying it. Now, of course, over time, I would say, it's been 20 years. So, of course, the economy has evolved. So the type of cases that we see have evolved, and we'll talk about this a little bit more, later during this section. So of course, now we do have some cases which I would say go beyond, or which flexibly adapt the principles in the guidelines to new situations. So I would say now probably neither the lawyers nor the in-house counsels nor the case handlers will sort of slavishly follow the guidelines, and first thing they do is to look in the guidelines. I think it was more important to have the guidelines at the time when it was new.
Thanks so much, Hans. It's very important to have a guidelines in this way, right? Let's ask Michael regarding the new drafts of the American guidelines as well. How can I talk about the draft one? What's the difference between this and the last one that you have it?
So they're very different. They are in draft form, but they were written by the FTC and the Department of Justice, so I think they do reflect the current thinking at the FTC and the Department of Justice. These guidelines, or the draft guidelines, don't really purport to be a statement of economic philosophy. The agencies take the view, we don't write the law, we're a law enforcement agency. Congress wrote the law, the courts interpret the law, and so what these guidelines do is cite case law. They cite U.S. Supreme Court cases. The U.S. Supreme Court doesn't get to hear very many merger cases. They really haven't heard one in 50 years or so. Some lawyer with too much time in his or her hands calculated the average age of the cases cited in the draft guidelines is 42 years old. So maybe they've withstood the test of time, but many lower U.S. federal courts have adopted the economic thinking in later guidelines, but the Supreme Court has not. So you can think of the draft guidelines as an encyclopedia of issues raised in merger cases from the 60s and 70s. And on the other hand, for the last 40 years, as a practitioner, you knew you needed to win the case at the agency, because if the agency challenged you in court, you were going to be confronted with these old cases with structural presumptions that were very stringent. And now you're dealing with those issues from day one. So parties need to be prepared to litigate, and really the way to get deals done now is to fix them first, and then you end up fighting in court over whose burden it is to show that the remedy has solved it or not. So we are back to big is bad for the first time since the 60s and 70s. the DOJ and FTC are tending to litigate everything. Settlements, consent decrees are only in very rare occasions. And with regard to vertical concerns and conglomerate concerns, there are really three guidelines. They don't really change all that much. Guideline 5 says mergers should not substantially lessen competition by creating a firm that controls products or services that its rivals may use to compete. And that really comes down to the ability and the incentive to foreclose. Guideline 6 is more interesting. I'm not sure why they broke this into two guidelines, but they did. Guideline 6 says vertical mergers should not create market structures that foreclose competition. They say that if the foreclosure share, the share of the related market that's controlled by the merged firm is above 50%, that alone is a sufficient basis to conclude that the effect may be to substantially lessen competition. Below 50%, you look at a bunch of factors and you argue about it. Then guideline 7, which really deals with conglomerate issues, is also very interesting. It says mergers should not entrench or extend a dominant position. What's dominant? Well, dominant means the power to raise price, reduce quality, or otherwise impose terms that they could not impose without that dominance, or it means a market share of at least 30%. 30% is a really low number for dominance on a global level, but that's what's in the guidelines. Then entrenching a dominant position means raising barriers to entry, increasing switching costs, etc. The more interesting part is in what it means to extend the dominant position. And what this means is, will the merged firm have the ability to leverage its dominance by tying or bundling or conditioning or otherwise linking sales of two products? That's really aggressive. I mean, you might think, gee, why not sit back and see whether the merged firm actually does that? And then you can use Section 1 of our Sherman Act to enforce that kind of conduct. But the answer that the agencies give you is no. We have an anti-merger statute, the Clayton Act, Section 7, in order to stop anti-competitive actions in their incipiency before they even happen. So that's very aggressive. So again, sort of think of the new guidelines as an encyclopedia of bad things about mergers from 50 years ago.
Mm-hmm. Yeah, that's very interesting. Amanda, based on your experience as a United Nations Program Development Consultant from CAGI, how do you think that the draft of the new no-horizontal guidelines is aligned to the international and the other guidelines that you have it?
Thank you, Fabiana. I'd like to thank Fabiana and Adriana on behalf of IBRAC for the invitation to join the panel. It's such a great honor to be here alongside with Leticia, Hans, and Michael. So first of all, I think it's important to clarify what was the job description of the consultancy that we conducted for CAGI. So it comprised 5 main papers. So all of them are very expected to be delivered and publicly available very soon. So hopefully in a while, all the figures that I'll provide here will be available for everybody as well. So the first paper, it comprised a quantitative analysis of the international experience on non-horizontal mergers, and it was based on a ICN merger working group survey. So the data collected from the survey from December 2022 was the basis for this first paper. The second paper was also a quantitative analysis, but at this point of the national experience. So based on a spreadsheet that CAGI provided for me, I could analyze 242 cases that were classified as vertical or conglomerate mergers that were decided both by the General Superintendents and also CAGI's Tribunal from 2012 to July 2022. So this was paper 2, both those 2 parts were quantitative analysis. Then it comes to the third the third paper, and then it came more with a comparative analysis of the existing non-horizontal mergers guidelines throughout the world. either specific non-horizontal merger guidelines or parts from a more general merger guidelines that was provided from other jurisdictions. And the jurisdictions that were analyzed were Argentina, Chile, Colombia, France, New Zealand, UK, Taiwan, and EU. We did not include the US merger guidelines just because it was published at the same day as CAGI's final deliver for public consultation. That's the reason. So otherwise, definitely it would be on our analysis as well. The fourth paper was a case analysis. So we decided to select one case that was analyzed throughout several jurisdictions as a methodological approach. And then we decided to see how Microsoft Activision Blizzard case was analyzed in Brazil and then UK, US, and EU to understand which were in practices the difference for those non-horizontal mergers that could maybe not be very clear on a guidelines analysis perspective. The fifth paper was then finally a proposal for a framework to the Brazilian non-horizontal merger guidelines as well as a methodological step-by-step flow. And with that proposal, it was possible to analyze the very good work that the team of CAGI already had done and to take this to comments from the general superintendents, from the tribunal, from the economic department, from the prosecutors, and to incorporate those contributions upfront before public consultation. So as a result of all that and answering your question, the Brazilian guide is supposed to be very aligned with the best practices of the most consolidated non-horizontal guidelines and also with the practice of the Brazilian with our national own experience as well.
That's very good. We are just keen to know the final version of the guidelines. Leticia, taking in consideration the change that have been, in these new guidelines, in which way do you think the analysis, the guidelines would require a change in the notification form, that's coming up?
Okay, I think that's a very important question to be able to clarify that the guide won't result in any procedural change, any formal change. So the information that is required, that is defined in the annexes of Resolution 33, they won't be altered by the guide. However, it is possible that as we get more experience in analyzing the vertical mergers and the conglomerate ones, we may find the need that some information, some specific information, maybe if it's given in the beginning of the analysis, can be helpful. This is already done in in mergers, especially when we have more experience in specific markets. When we have the pre-notification meetings, we usually already ask for this, or even the lawyers or the firms already know, already give us, even though it's not required officially. So of course, that is bound to happen, but formally, there won't be any change.
Okay, that's important to know. Hans, regarding the European Commission, we know that the guidelines have not changed since 2008, right? But you do have some changes in the day-by-day investigation it has been done. Could you just explain, compared to the recent case, the Illumina Grail, for instance, or any others, and the recent adoption of the merger control simplification package, could you just discuss how does it is going to be changing in the way that you analyze the case in European Commission?
Yes, thank you. So, obviously in 20 years a lot has changed, and of course we've adapted the way that we apply the guidelines. I think also in large part the economy has changed in the sense that we see now a much larger importance of digital markets, of tech markets, where you tend to have network effects and scale economies, which give rise potentially to greater opportunities for firms to foreclose rivals. In these markets, sometimes also data plays a particularly large role, which may allow a firm to target foreclosure in a very specific way. So I think you have technological changes which allow firms to think about strategies of foreclosure that depart somewhat from the static situation that probably the guidelines 20 years ago mostly had in mind. I mean, the guidelines are written a bit in a way, as, I don't know, maybe a producer of aluminum would foreclose, some purchaser of aluminum in the market afterwards. But of course, in digital market, foreclosure often, doesn't only have this sort of raising rivals cost idea, but maybe there to protect some markets in the future and things like that. And those are topics which are hinted at in the guidelines, but they are kept extremely briefly. And I think these dynamic topics, they play a much larger role in our enforcement now. You mentioned Illumina Grail. I mean, that's a case which was about, the risk of foreclosure in some future market. We had other, we had a large number of tech mergers, which, Microsoft, Activision being one of them, which you can look at from a sort of classical perspective where you say, well, Microsoft will now get access to Call of Duty, this very important game, and they may foreclose Sony from access to it. But I think in these cases, what we've tried to do is to take into account that these are changing markets. So the way people are playing video games today is likely going to be very different from the way they may be playing them in 10 years' time. They will not have anymore the CD that they put in some physical console. So, and that's why issues like cloud computing or subscription services, which are only in their incipiency right now, nonetheless played a significant role in these cases. Finally, I will mention Booking.com, eTravel, which was a prohibition decision, where the theory was much about entrenchment of booking and not so much about foreclosure. So I think there are some areas, especially in the tech space, where basically our enforcement has evolved beyond the sort of static thinking that mostly dominates the guidelines. But I would say, it's consistent with the spirit still of the original ideas.
That's very important as well. It's coming up any new guidelines in some time soon?
I would not necessarily expect this. I mean, your guess is as good as mine. I don't have any secret information about it, but you have to see, writing guidelines is can be a very political thing. And at the moment, as we've seen with the US guidelines, antitrust is very much in the focus of politics. Yeah. And that has certain benefits because, of course, as a regulator, you may be felt to be more important than, let's say, 10 years ago, where this was, basically for us geeks sitting in some niche hotel, discussing among ourselves and nobody else understands it. But that's different now, right? I mean, now the politicians have an opinion on this. And so this is good in some ways of making our work count. But on the other hand, of course, we are also in a times of sort of populist political debate. So there are also risks from politics getting into this. And Europe is a complicated construct, as you know, with many different member states and many different ideas. So I think, people would probably not open this process unless there was a very clear idea for a significant change that is necessary, but not just to add a chapter here or there.
Right. Yeah, makes sense. So let's just change for the procedure analysis topic now. I would like to ask you, Michael, how have American courts have been challenged the decision and the use of economic models and in other economic matters, and how both the parties and the authority have been recognized this challenge?
So let me answer that question, but first, just to answer from the U.S. perspective, the question just asked Letitia about whether there'll be changes to the information requirements with the new guidelines. Even more significant in the States than the changes to the merger guidelines that are proposed are the changes to pre-merger notification, which probably going to affect, my guess is by the end of the year. I don't have any inside information either, but we're changing to a system that will be much more like a Form CO or a long form with CAJE, but without any fast track procedure or any short form procedure, and without any system of pre-notification. So while it takes me a week, maybe two, to put together a Hart-Scott today with a reasonably responsive client, it's a couple of months at least, and the volume of data and information is just astronomical. I don't know what staff is going to do with it all, but they're going to get it because they're requiring it. So with regard to your question now, so litigation often becomes a battle of the experts, and courts struggle with this. Judges are not necessarily trained economists. They're not. But what they do for a living is they assess credibility. So what I've seen in a number of cases recently is that the judge will listen to the experts and they will choose which one is correct and which one is not correct, and then write opinions that are so one-sided. I mean, I'll give you some examples from a recent trial involving American Airlines and JetBlue, which had sort of it was a quasi-merger, and the DOJ's primary expert was Dr. Nathan Miller. The court found him a thoughtful, credible, and well-credentialed expert who was articulate and methodical. And more than any other expert, he was consistently measured and precise in his responses. Now, the defendants had 4 expert witnesses, including some big names in antitrust economics, Mark Israel, Dennis Carlton, Darren Lee, and the judge just ripped them all to shreds. So first of all, he notes that all 4 of them worked for the same consulting firm. 2 have written papers that were funded by a global air network carrier. American had retained at least 2 of them before, and the judge decided that based on their demeanor and tone, they were much more like advocates than impartial economists. So with regard to Mark Israel, who was the lead, he demonstrated a misunderstanding and misapplication of antitrust concepts. He found Dr. Israel's conclusions overly simplistic, and some other parts of his opinion the court found to be absurd, arbitrary, and unfounded. So as a result, his opinions were entitled to no weight. So for the practitioners, you need to adjust to who the judge is. Often it's very tempting to use the economist to bring the whole case together, and that works very effectively sometimes, but other courts don't think that economists have any specialized expertise in interpreting documents, so that can be dangerous. From the DOJ's perspective, they are placing less emphasis on econometrics and on modeling than they did in the past, with the possible exception of perhaps when they really helped the case, but maybe I'm being cynical here, but Jonathan Cantor has spoken about how economics they're just tools to understand facts relevant to a particular case. I think he's much more persuaded by documents and by natural experiments. Econometrics does make it into the draft merger guidelines. They're sort of buried in the back of a section on sources of evidence that's sort of at the back of the guidelines. So it's still there, but I think the emphasis is on documents and real-life experience.
Yeah, documents more like as the evidence that you can just have as a concrete, evidence. So that's why they are just posing this challenge, right?
I think that's fair.
Yeah. Amanda, again, from your experience as a consultant, what are the main difference, if it's any difference, between the analysis presented by the guidelines in the different jurisdictions that you have been, working this work in as a consultant?
Yes, so when it comes to the paper 1, when we had these quantitative analysis of the experience throughout the world, It's interesting to know that out of the 28 jurisdictions that were respondents of the survey, 93% of those jurisdictions answered that they use capacity incentives and effects steps. So this means that the Brazilian guide is very aligned with the steps that are typically provided around the globe. And we when we had the paper 3, specifically detailing the experience, the international experience on those steps, we mainly focused on the UK and the EU existent non-horizontal guidelines, and both of them very strongly use capacity incentives and effect steps. And they have specific sections on their guidelines providing which are the questions that should be asked in each of those steps. So when it comes to step 1 on capacity, typically the question that is asked is there capacity for the implementation of anti-competitive strategies by the integrated company? And then if step 1 is fulfilled, then it's possible to go for step 2, which comes for incentives. And then the question would be, does this integration generate changes in the incentives structure for anti-competitive strategies? So it's important that only if the applicants have capacity and incentives that the analysis go to the 3rd step, which is the effects. And then the question would be, if there is this capacity and incentive that is necessary for this step, does the implementation of such practice generate effective impacts in competitions with final losses for consumers? So this is typically the analysis that is conducted also in the Brazilian experience, that we inserted this in the framework of the guide, very aligned with the major jurisdictions abroad as well.
Yeah, thank you, Amanda. Now I want to know about the safe harbors. We do know that the guidelines have some safe harbors. Hans, when you're talking in European Commission guideline, what do you think about the safe harbor? How do they really align to the real case? I mean, do you really consider it as a safe harbor, or you just put in consideration other aspects of the case?
So yes, I think, the main safe harbor in the EU guidelines, I would say, is that, if you don't have a really very important upstream input that can be used to foreclose, but if there are alternatives, reasonable alternatives for buyers, even if not perfect alternatives, then there cannot be significant competitive harm from foreclosure. And the easiest way this is usually measured is simply the market share. So saying like if the upstream market share is relatively modest, not so high, then there's no risk of foreclosure. And I think having this sort of safe harbor for lack of ability is extraordinarily important for businesses. Because then they know when they make a takeover for certain types of deals, they really don't have to go through a very complicated analysis. They can do it with their in-house team and an external lawyer in a relatively quick time without having to involve large teams and stuff like that. So I think it's very important. Now, I would make one qualification. I think market shares here and in also other areas of merger control are not always a great measure of market power. So of course, you may have markets where the input is, let's say, some plastic tool. And in this particular plastic market, maybe there's only 2 people with 50% market share. And then, sort of technically you would say, oh, wow, they control 50% of the market. If they foreclose their customers, that's really damaging. But, plastic is so simple. There's like a million guys around who could step into this market very quickly if prices rise a tiny little bit. So in that case, sort of using the market share as an indicator of potential harm is not very smart. Now, on the other hand, you can also have it in the other direction. You have certain very differentiated markets. You know, I'm thinking of, we had various mergers involving Luxottica. Luxottica is an eyewear brand, so they have Ray-Ban and Oakley and basically all the brands of glasses that you would know. Is like 90% of the brands are with them. And these guys, if you measure the market share that they have, it's not all that dramatic. I mean, you can cut the market and sort of, you know, expensive glasses, not so expensive, and so forth. It doesn't make any difference. So they will never be above 50% anywhere. Yet, they have all the important brands. So for the stores that rely on them, it's really a must-have product. You know, you cannot be there without having Ray-Ban. You know, if you're one of those stores that caters to a particular type of customer. So for them, even though they may have a market share of only 30%, you know, the input is very important. And so I think there is where one should use this safe harbor, you know, in an intuitive sense. And that may sound like effects-based and very complicated, but I think firms know quite well whether, you know, the stuff that they produce is essential for the customer or whether not. Michael may have a different view on this from from counseling clients.
So maybe there's a market for branded sunglasses or high-end sunglasses, in which case they do have a market share. But we don't have safe harbors under the new guidelines. I guess the concept is still valid that if your market share is low enough, there's no real degree of risk of foreclosure, but there's no safe harbor. There's no, and I didn't hear one from you either. Maybe there is, but there's no. Gee, if you're below 30%, you're okay.
Well, in Europe, there's a stricter safe harbor, but I would also say it's kind of a sliding scale. Yeah, I mean, I think if the Commission wants to bring a case against Luxottica with whatever a 30% market share, then I think the evidence that we would have to bring would be extremely compelling. On the other hand, if somebody argues that he has 80% market share and there's indications that there's an incentive to foreclose, you know, they'd have to bring very, very compelling evidence. So I mean, the degree of evidence will slide on that scale, I think.
That makes sense. Leticia, we know that the draft guidelines has like 30% of the safe harbor, the threshold. What do you say about, you're going to be taking in consideration this 30%, or how it's going to be in the, in the analysis that you're going to have in the future case?
Okay, as I mentioned earlier, the guide won't change. So we have the thresholds that are in the law, in the resolution of 20% and 30% for vertical mergers, and that's not going to change. But of course, it's the same thing as that already happens. These can be flexibilized, and they are. A lot of times by CAGI, just as Hans mentioned, I remembered an interesting example that's similar to his. And I think here, Luxottica também, we also had less than the market share, but it was analyzed. But I remembered Nike Centauro, that Nike had less than 30, and we acknowledged that in the report. But as it was such an important brand, and for the other distributors, it was so important, we went through the whole analysis and not the fast track, because we thought it was relevant. So of course, that as we're going to start having more and more experience with vertical and conglomerate mergers, so these things are going to happen more often. So we're not binded by the thresholds, as we won't be binded, I forgot to mention that, by the guide, of course. So it's going to be as we do now, but with more experience, it'll be easier maybe.
So it's going to be like a yellow flag, but for sure you need to combine the other aspects of
yes.
the case, or depends on case by case.
On the market.
In the market. So let's change to tier of harm. Amanda, based in your experience as a consultant, what is the main tier of harm that you have been analyzed in the other jurisdiction, and that you can just explain to us regarding these matters?
Great. So based on the answers of the jurisdictions, we have three main theories of harm that are analyzed in all jurisdictions. which are input foreclosure, customer foreclosure, and conglomerate concerns. And it's interesting to know the figures. So 85% of all jurisdictions, respondents, answered that they do analyze input foreclosure. 93% answered that customer foreclosure is analyzed, and 89% is the answer for conglomerate concerns. So this means that customer foreclosure is the main theory of harm out of those three typical theories of harm that are analyzed in all jurisdictions. In detailing a bit those input and customer foreclosure theories of harms, the main concerns would be either total foreclosure, but also partial foreclosure. And the risks that are typically taken into account are price increases, but not only prices, but also quality degradation, interoperability or access to IP, dynamic effects. One point that is increasingly taking the attention of authorities, which is ecosystem theories of harm, also strengthening of dominant position, and also access to upstream services. But when it comes to new theories of harm, those new theories of harm, they are typically taken when we are analyzing the so-called digital ecosystems as well. And then we have more different, I would say, or more new theories of harm, which would be tie-in and tied sales of digital services provided by these ecosystem. The second one would be the envelopment of digital service. Also, foreclosure strategies, but on adjacent markets. And also a fourth new theory of harm would be the decreased digital competition in the long-term scenario. So those are the four main new theories of harm that may be observed so far from the international experience.
Thank you, Amanda. So having in consideration this tier of harm, Michael, how the tier of harm have evolved and challenged, even compared to this digital ecosystem, harms? What do you think in your views?
From a U.S. perspective, what Amanda said. I mean, that's really the way it is. I mean, she did remind me that 97% of all statistics are made up on the spot, but beyond that, that really, those are the concerns. It is, so Guideline 10 talks about theories of harm in multi-sided platforms, and the concerns are that the acquisition of a platform participant by a platform owner may entrench their position, may foreclose the opportunities for other platforms to gain network effects, to gain the volume that they need. They also, I guess there's one that maybe you did mention, is that the acquisition of a participant by a platform owner gives rise to a conflict of interest. So think Amazon. But other than that, I mean, those are exactly the same theories. And I think you expressed, actually, having read the V+ guidelines, they're very consistent with the thinking in the U.S. I'm not sure who went first. Oh, the same day. Maybe there was coordination, but they are very, very similar. Same week, sorry.
But what about the sensitive information, the access to sensitive information, how they are evolved in terms of the tier of harm in vertical case?
So lots of vertical cases used to be resolved where it's access to information by consent decree. Set up a firewall, and that solves the problem. The U.S. agencies are extremely skeptical of those solutions now, and they don't enter into those consent decrees anymore. So the concern is that they'll use that information to restrict competition, and it's not hard to figure out the ways in which that could happen, but the concern is that firewalls just don't work.
Yeah. So I want to know from Hans about also the sensitive information. How is the boundaries, which is going to be an advanced or anti-competitive concern? in vertical case as well?
Right. So, I mean, clearly it's an important topic in vertical cases. On the one hand, you have the issue of collusion, which, where basically vertical mergers can be used as a hub for exchange of information to have a downstream cartel. But I think what you refer to is more sort of the exploitation of information from a rival for the own downstream unit. And there, I think we have very few cases, I should say. We have a bit, but I think it's important also to realize that not any form of information that's transparently given is necessarily bad for competition. So for instance, if we are in competition with each other and I know your cost, and before I wasn't sure, that may make me more aggressive or less aggressive. Yeah, if you for instance happen to be have lower cost than I initially thought, then having this information actually will make me compete harder because I realize, oh damn, I better get my stuff together and compete. So I think in our cases, we've limited intervention, I think, usually to situations where there is some very, very clear risk of appropriation of very sensitive, innovative information. So if you have one innovator competing with another innovator, and think for example of the NVIDIA ARM merger. This merger was abandoned. Yeah, ARM is producing the semiconductor architecture for mobile chips and graphics chips and so forth, and they were supposed to merge with NVIDIA, which is one of the biggest user of this architecture in order to provide chips for computers and servers. And obviously, when you have this chip production and you have some architecture that evolves by ARM, they stand in permanent contact with Apple and Qualcomm and all the other chip producers, and then they exchange what their respective plans are. So, Qualcomm may tell them, look, the way we want to change chips in the future is going in this direction. Can you, change the architecture in a way that makes it easy for us to do it, and so forth and so forth. This sort of thing. And so obviously, when there you provide as a chip producer such sensitive information to someone who's now owned by, your main competitor, obviously you're going to feel very reluctant to give this information, and there, this case was abandoned. So, I'm not making a statement about this having been necessarily a problem, but this was the concern raised there, and I think this is these sort of very clear, seemingly clear cases is where we would look at. And by the way, I share the skepticism about the Chinese walls to a degree, simply because I think it's so hard to police and so easy to get around.
Amanda, talking about the foreclosed tier of harm, how they are dialogue with the raise and arrival costs? If you take in consideration the guidelines, they are really similar, but can you just explain better what you think in terms of the analysis of this concern, the competitive concerns?
Great. So Steven Saleb, which is a scholar, probably most of you know, he has one understanding that some business conducts could be better explained by the increase of rival costs, not necessarily by the conduct of foreclosing inputs and customers. So although raising rival costs is mentioned as an additional theory of harm, and also in the Brazilian guidelines, there is a section specifically on raising rival costs, raising rival costs strategy tend to be a more subtle form of implementing market foreclosure strategy according to scholars and also to the case law in Brazil and abroad. And it's interesting to know that this was the analysis of the Activision Blizzard case, which was under scrutiny on our paper 4. And when we read carefully the CMA decision, it took into account several forms of implementing the market foreclosure strategy. Two of them were also mentioned by Hans before. So the foreclosure theory of harm focused on console gaming. This was the first one, and which may be more typically analyzed by us if you or your kids play video games when we see consoles. But the second theory of harm was based on cloud gaming service, which was more a new market that is increasing. And when the CMA was developing in its analysis of these partial foreclosure / raising rival costs, it asked some questions which may provide some examples for us of how could these be implemented. So they asked, will the future Activision content be made available with a delay for competitors? So it will be maybe a timed exclusivity. Will there be any degradation in the quality of the games or the graphics of the products that are provided in other rivals platforms? Will Activision provide their games to other platforms will it provide some content only to the integrated Activision Blizzard game, or will it provide this content also to competitors? And also, will Activision increase the prices of the games only for its rival and not to their own platform? So those may be some examples from one case that may bring us this idea that typically we have raising rival costs as an additional theory of harm, but in practice they sometimes definitely can overlap with partial foreclosure theory of harm as well.
Especially concerning the effects, right? In terms of the effects, I mean, if you take the two in consideration, the analysis is going to be kind of the same effects.
Yeah, probably when we have the three steps, capacity, incentives, and effects, probably the analysis will be, they may come up with the same result, but also the same defenses may be provided for both as an efficiency as well that may be provided by the integration as well.
And Michael, what's your, thoughts on this strict foreclose effects?
So even under the guidelines which set up these presumptions, it's not a strict, it's not a per se violation. You still have the ability to rebut the presumption. And what Guideline 5 tells you is that what you need to show is evidence that there is no plausible way in which the merged firm could profitably worsen the terms for the related product and make it harder for rivals to compete. So that's a tough standard, but it can be met. So I'll tell you a war story that from about 5 years ago I was representing, together with excellent economists from Hans's former firm, a company that had more than a 30% share, so therefore dominant under the guideline standard in hemodialysis clinics, where people go to have their dialysis treatments. And they were acquiring a firm that was essentially a merger to monopoly in home hemodialysis machines. So why was that vertical? It was vertical because even if you are doing your dialysis at home, you need to be affiliated with a dialysis center, you need to get training there, you need to go in every month or two for refreshers and testing. And so the question was, will this put my client in the position where it will have the ability and the incentive to either completely foreclose their rival dialysis centers by refusing to sell them these home machines, or reduce or affect the terms of sale, either giving them lower quality machines or not being as responsive, or not fixing them, whatever. So we did a complete analysis. I think it's sort of like the vertical math that you've written about. We looked at the margins in both the dialysis centers and in the machines. We looked at the likely diversion, made some assumptions on what kind of diversion there would be in response to either complete or partial foreclosure, which really means reducing increasing the price or reducing the quality, and we showed and we looked at, would we have to open more dialysis centers and what would the cost of that be if we succeeded in foreclosing. We looked at would we be incentivizing our rival dialysis centers to sponsor entry by other home hemodialysis machines. We took into account the reimbursement rates, which sort of varied, and did the complete analysis. We were aided by the fact that we sort of had a natural experiment in that for a period of time, my client was the sole provider of a pharmaceutical that dialysis centers needed because one of their rivals had an issue in their production, and we had done no discrimination at that point in time. We were aided by the fact that there were no bad documents, that the models for the transaction, the financial models showed the continuation of the intent to sell without discrimination home hemodialysis machines to the rivals. So it was a full second request. It was a complex analysis, but that's the kind of work that I think is expected to be done, and that can be done when you have the facts on your side.
Thank you, Michael. So getting back the V Plus guide, Leticia, the Brazilian horizontal guidelines, they has incorporated the conglomerated effects. Why is that? Can you just explain better?
Why we
included the conglomerate effects, the tiers of harm.
Yes. So initially, going back to the history that I told of the guide, initially in the discussion, we were not going to include it. So it was going to be just the V guide. And we decided to incorporate. Why? Because first, we were starting to see, I forgot to mention that in the beginning, that in the last 10 years, we have seen an increase in vertical mergers, and that's why we started also discussing by CAGI. So the need to have the guide. And that the same thing happened with the conglomerate. We don't have as much experience as the vertical mergers because we haven't seen that many cases. But we thought it would be important to include because this discussion is going on not only in Brazil, starting to, but in other jurisdictions as well. So we thought, as we're launching the guide now, it would be important to mention the conglomerate, maybe not so many details, of course, as the vertical that we have more experience in. But so we decided to include it, and it lists some hypotheses of anti-competitive effects that can result from conglomerate mergers, and that should be taken into consideration when analyzing a merger. Of course, it doesn't list all effects. It's not, and I think it's important to highlight this, and this goes also for the vertical merger part. It's not an exhaustive guide that lists everything that could happen. I think, exactly, our superintendent has mentioned this in other occasions, that it's not our final say in the matter. And I think even Hans mentioned, like, the guidelines, their guidelines is from 20 years ago. Of course, the analysis changed over the last years. So we're doing, the guide is based on our experience until now. And of course, it's going to evolve as we have more experience in the matter. So I think it's very important to take that in consideration. And also that we couldn't go into so much detail in the guide. I don't think that's what guides are for. But CAGI has other publications that they can go in more details in specific subjects. So relating to conglomerate mergers, recently the Department of Economic Studies published a document yes, that they were able to go into detail and analyze it. And it's also a publication of CAGI, so the guide is not supposed to be read by itself, but also with the other documents CAGI publishes and has the opportunity to dwell more on a subject and dive more into it.
So, Amanda, in your research, what can you say about the main difference and challenge with a conglomerate case?
The first main challenge would be the concept of conglomerate merger. So the definition that would be provided by several papers for the OECD, for other scholars, and also in case law, is defined by exclusion. So a conglomerate case would be those that does not encompass horizontal, vertical, or quasi-vertical relations between companies. So if it's not horizontal, if it's not vertical, maybe that's a conglomerate merger. So first difficulty would be to classify a merger as a conglomerate merger. When we come to the ICN merger working group research, based on the answers of those jurisdictions, there are at least 8 main concerns related to conglomerate mergers. So the first would be technical tying, the second contractual tying, the third pure bundling, the fourth, mixed bundling, the fifth, dynamic effects, the sixth ecosystem theory of harm, the seventh, the strengthening of dominant position, and the eighth, access to upstream services. So those are, up to now, the main theories of harm of conglomerate, but as the document published by CAGI as well very recently, specifically on conglomerate mergers. Over the last 2 years, we had 50% of all conglomerate cases in Brazil. So probably throughout the next years, we will have more experience on conglomerate mergers, and then be able to delve into those theories of harm and see if those are the main theories of harm on the Brazilian perspective as well.
Thank you, Amanda. Michael, as you have the draft of the US guidelines, why they do not differentiate the horizontal, the vertical, the conglomerate? Why is that?
Well, they do use the term vertical in places, and I didn't write them, so I can only speculate, but that won't stop me. I'll just speculate. I think the thinking is that yeah, there may be horizontal, and I think this point is made in the V+ guidelines, there may be horizontal effects and vertical effects and conglomerate effects in the same merger, so why engage in label making? Just look at what the effects are and don't have to give it a name. There may be 8 issues that are problematic with conglomerate mergers. There are 13 guidelines in our new set of merger guidelines, but guideline number 13 basically says anything else that's bad about the merger. So you know they do use vertical, but I think the idea is to look at mergers holistically.
Okay, thank you. So change it to the ecosystem digital case. Hans, can you just talk about it, how it's going to be addressed in European Commission, this type of harm?
It's a good question because this, I think, is a very novel type of theory that I would say is at the moment very ill-defined. People mean extraordinarily different things when they speak about ecosystem theories of harm. I think largely what it means is usually a strengthening of a dominant position or an entrenchment, by adding further complementary products in a way that harms competition. Now, of course, one has to be very, very careful here that the strengthening of the dominant position is not simply an efficiency offense, because obviously, you know, if you have a good range of products and you improve your product range in a way that consumers like, you know, that makes your product better, that may well, you know, lead you to be stronger afterwards. That's the reason why you do it, but it's not necessarily anti-competitive. I will give an example of where I think these ecosystem theories, you know, that is going beyond foreclosure, you know, can be very important in tech markets. If you think of, you know, tech ecosystems, digital ecosystems, so, you know, several apps that are complementary and that are included, let's say, in a suite of dominant products. And then somebody else is purchased who does not directly compete with any of those products, but is complementary to it or at the boundaries of that ecosystem. And if that target has some really special capabilities, there is a risk. And the risk is the following. You know, if you look at somebody like Google, or if you look at somebody like Facebook, or, you know, any of the other big tech companies, it's very, very hard because of network effects and scale effects to directly compete with them. I mean, the risk for Google is not that DuckDuckGo will, you know, conquer the world and, you know, all of a sudden be the dominant search engine. That is not going to happen. We know that. So the risk for Google is that somebody comes with a kind of complementary product that in the beginning doesn't really get in the way of Google. You know, something like ChatGPT, which, you know, can be used alongside with Google, which doesn't really directly compete with Google or only at the margins, but which clearly has the potential of developing into something different in the future. And I think that's the right way of looking at this question of mixing horizontal and vertical. You know, I don't like at all just to say, oh, it's all the same. We just look at market shares. It's not. Horizontal and vertical mergers are fundamentally different. And, you know, there is a much higher likelihood of benefits of integration from non-horizontal mergers. However, I think we have to be very, very careful that we do not, you know, forget that these products can change in changing industries. And that's the way how you compete with Google or how you compete with any of these firms. You build something complementary where you don't step on the toes of the dominant firm in the beginning. You scale up, you build based on some capabilities, your own network effects. And then once you're there, you can start integrating functionalities into your product that then directly compete with the dominant firm. And that's the risk, and that's where I think it's very important to look carefully at.
Thank you, Hans. Change to efficiency. I would like to ask Leticia if there is any specific factors or evidence that you can just balance when you consider the efficiency, especially in vertical case, how to outweigh these factors.
I think first it's very hard. The efficiency analysis is always complex, not only for the lawyers or for the third parties outside, but also for the case handlers. For the authority. It's hard to determine specific factors or evidence that can be brought like beforehand, or that we'll surely consider. I think it's hard. It's very case-by-case analysis. That being said, of course, the vertical mergers, we already know that different than horizontal mergers, they tend to bring more efficiencies by reduction of costs, elimination of double margin, etc. So of course this is going to be taken into account. In the guide, as I mentioned before, we do list these efficiencies so we already, of course, will consider that. But the difficulty here, of course, is showing that these efficiencies will occur, because they have to be probable, be verifiable, be measurable, be specific of the transaction, and occur quickly in 2 years. And I think the biggest challenge is showing that they will be passed on to consumers. So of course, I understand that that's a big challenge. But for the authority, it's very important to guarantee that, or to have at least be certain that will probably occur. What we have seen, and I think this is also mentioned in the guide, it's that maybe there are information that is exchanged between the parties beforehand, or even to stakeholders or to other agents, that maybe that can show that there is incentive to pass these efficiencies on to consumers, and that may help us or help the authority when analyzing the merger.
Contrafactual,
Yes.
scenarios. Okay.
So maybe that can be very helpful. But as I say, it's very hard. It's depends so much on the merger, on the operation, on the parties, on the market.
Amanda, do you have any thoughts based in your research concerning the efficiency?
Yes, so 20 out of the 28 jurisdictions analyzed by the ICN research answered that they take the following efficiencies into consideration in those non-horizontal mergers. So the first one, and the 20 of them consider elimination or internalization of double margins as one of the main efficiencies. Also, and this is interesting, more than EDM, which is typically more considered, 22, which means 2 jurisdictions more than the other one, consider cost savings as one of the most important efficiencies of those mergers. 17 consider reduction of the risk of hold-up, and also 21 answered all other concerns, other efficiencies, such as critical loss calculation. And also, of course, there is a matter of the verification of those efficiencies. And then the standard that is mentioned, at least by those authorities, is that it has to be submitted by the parties, it has to be timely, it has to benefit consumers, it has to be verified, verifiable, they have to be specific. So I think Brazilian experience is already considering those efficiencies standards on an aligned way with the other authorities as well.
Thank you, Amanda. So I would like to know from Hans, what weight the efficiencies have in the vertical case in Europe, and what kind of economic model, if I can say that, we can use to bring the efficiency to the case?
Thank you. So I think if you would ask parties in the cases, they would say, well, we don't see the European Commission accepting efficiencies very often. And that's factually correct. It's very, very rare that we have cases where we say, well, there would be a big problem, anti-competitive effects, but there are even larger efficiencies. I would say, however, that this does not mean that efficiencies are not taken into account, but it's simply the case that usually when we see a case where we see, well, there are significant benefits and maybe the harm that we can show is a bit shaky, we're not going to get into an analysis where we're going to say, well, the harm is 12 and the efficiencies is 13 and that's why we clear. But in those cases, we'll simply not raise a concern in most of the cases. So I think efficiencies are there and are considered much, much more often than people may acknowledge. I mean, simply from the fact that really the vast majority of non-horizontal mergers is cleared in the European Commission, is a testimony to that, even though, of course, there are a couple of those mergers which involve really high market shares. Now, we have had some cases where we had a quantitative assessment of weighing harms and efficiencies, so this does happen. It has happened in particular with respect to elimination of double marginalization, where it's relatively easier to quantify than in other areas, and where you can integrate it with the usual sort of quantitative tools to measure anti-competitive effects. You can sort of use the same model, if you will, to measure or to compare the efficiency with the competitive harm. We've done that in particular in mobile telephony mergers, where there's often sort of some vertical integration, so there may be some horizontal aspect to it, but there's often, also some network being bought so that they can buy the access of the other firm in some areas of the country. And for those, we acknowledged elimination of double marginalization, and it was quantified in the decision. We had the same in some retail mergers. So this stuff does happen. But as I said in the beginning, it's rare that this is sort of the final part of where the decision plays out. Usually we would bring cases where we believe that efficiencies are not significant and are clearly not significant. And when we do not bring cases, then more often by saying there is not significant evidence of harm.
What's your views in US, Michael?
Very, very similar to the European approach. Efficiencies will not save a merger. Having said that, you need to have a good business reason for doing the deal, and that business reason cannot be we want to foreclose or discriminate against our rivals. So, so you do tell that story. But close your eyes a minute. Imagine you can go all the way back to 2020, when the vertical merger guidelines in the United States said, due to the elimination of double marginalization, mergers of vertically related firms will often result in the merged firms incurring lower costs for the upstream input than the downstream firm would have paid absent a merger. This is because the merged firm will have access to the upstream product at cost, whereas the downstream firm would have paid a price that included a markup. So that's 2020. 2021, Lena Khan comes in and immediately she withdraws the vertical guidelines. Why? The vertical merger guidelines' reliance on the elimination of double marginalization is theoretically and factually misplaced. Empirical evidence suggests we should be highly skeptical that EDM will even be realized, let alone passed on to end users. So there's a lot of skepticism, and they cite a couple of examples: acquisitions of physician groups by hospitals, AT&T's acquisition of a satellite provider, satellite TV provider, and where they claimed EDM and then raised prices afterwards, but a lot of skepticism. But having said that, you do need to have a business reason for doing the deal, and it's got to be one other than foreclosure.
Thank you, Michael. So let's change to remedies, Amanda. I would like to know in your research which kind of type of challenge you have been accessed in terms of to remedy this vertical case, and which kind of remedies they are bringing into the solutions.
Yes, this is a very good question, and I think this is the one which will be mostly non-answered, because at least none of the guides that I was able to analyze for the consultancy had a section on remedies. So this means that at least to this point, there is no focus, or at least a specific focus on remedies on vertical and conglomerate mergers. And this does not mean that we don't have to reflect and to evolve on that. This is my perspective that when we have those non-horizontal mergers, probably we will end up putting more gray area on this distinction on behavioral remedies and structural remedies, and especially on ecosystem, digital markets, we will probably have remedies that I may call them now a sort of quasi-structural remedy that may be in a part either structural or behavioral, but they couldn't be really classified as traditional ones. Probably this is the area, at least in my point of view, that researchers and case law will mostly delve into for further development and implementation of some changes.
Thank you, Amanda. So I would like to ask Hans and Michael about any emblematic case in which remedy was accepted. And can you just, tell about it and any specific case?
So I'll start. They're not. I think they really are. These really are remedy cases. So let's talk about Microsoft Activision. So let's talk about foreclosure. It's the ability and the incentive. Did Microsoft have the ability to foreclose access to Call of Duty? Yeah, they were going to own it. So the ability was there. Did they have the incentive? well, gee, they cut a deal with Sony. That was a remedy that they did themselves. They fixed it first. And that remedy, I mean, essentially, I think that's what persuaded the judge that they didn't have the incentive to foreclose because they'd cut the deal with Sony and sort of solved that issue. You can say that's a victory for the FTC, even though they lost the case. They got the remedy that probably solved the issue, did solve the issue from the judge's perspective. Illumina Grail, Hans had mentioned earlier, that's one, so there's a complex litigation history. The Federal Trade Commission trial court level is the administrative law judge, and the administrative law judge bought the idea that Illumina's promise to make the products available was a remedy and was sufficient to avoid any foreclosure risks. The full Federal Trade Commission didn't agree with that. That's now on appeal. But these are examples of what I was talking about at the outset. You need to fix the merger yourself. We'll see whether or not the Illumina Grail fix is going to be upheld. Finally, it's going to be a question of how much deference the court gives to the FTC, but that's a whole issue. But I see all these cases really as the theories are there. No one's questioning the theories of the ability incentive to foreclose. The question is whether the remedies that the parties are adopting themselves are sufficient to cure the issue.
Yeah, I think, in non-horizontal mergers, it's always a very big question. Do you have a structural remedy or do you have a behavioral remedy? And I think, in particular, the UK Competition Authority and also to some extent the US agencies have more and more taken the view that they will only accept structural remedies and that behavioral don't work. And, obviously there are good reason to find structural remedies more attractive. The behavioral remedies, they need to be monitored, which can be very hard. I mean, often, especially when the product is changing, it's not so easy to write a contract that exactly specifies what you want, what the price will have to be in 5 years when that product is changing. It's not always easy to detect foreclosure even and to contractually sort of, define what foreclosure actually is. And a behavioral remedy does not take out the incentives, the underlying incentives. So there's a problem, and they're limited in time. That being said, I think our experience with behavioral remedies has not only been bad. We'll give one example. So we had the German mobile case, so that's a mobile telephony merger in Germany, where the remedy that was used, 8 years ago or whatever it was essentially giving a very small MVNO, so a very small access seeker, access to the market and to spectrum of a very significant kind. So this was basically this garage firm that entered, and then from the merging parties had to be given access to the network. And with that remedy, you could see both the benefits and the downsides of behavioral remedies. The downside was that because mobile telephony services change so much, the internet needs change and so forth, and then what's the right price for this? So there was a constant struggle about what's the right price, what's the right volume, and so forth. So it was hard to supervise. On the other hand, what this remedy did was basically they established this player in the market, on the downstream market, but once they were there and had the customer contact, the next time around that spectrum was auctioned off by the government, they had the opportunity and the incentive to take part in that auction. And so they did. So now we have 5G. So this little company that started in a garage, all of a sudden now is the fourth player in Germany with their own network, which they're building. So in that sense, it was a tremendous success. Even though it was a behavioral remedy, it basically gave them a helping hand in order to then develop themselves in a structural way. That's why I would say, from my personal perspective, I would not necessarily say that behavioral remedies are always bad. It really depends on the case.
Mm-hmm. Thank you, Hans. So it's about the time. I would like to ask if you have more question from the audience. Anyone? Adriana?
So thank you very much for the talk. I'm Adriana Perez from Tendências. So I'm very interested in the discussion about the guidelines, right? Because the guidelines are very important because they give transparency, predictability, right? And they also, one thing that is very important, they also protect authorities, protect the staff from political pressure. So I was very interested when Hans mentioned that since we live in populist times, it's important to have this toolkit very well organized. So I really appreciate that point. I just wanted to mention the panel on artificial intelligence is occurring just right now, but I'd like to bring this point because we see that it's going to bring a huge huge, probably, I mean, it seems that's going to be a lowering of the entry barriers, right? So you mentioned the case of Google, ChatGPT, maybe it's becoming some sort of complementary service that instead of looking at Google, you go to ChatGPT and you look for the information. So how we are ready to, if we have the toolkits to handle this probably overwhelming change in this lowering of barriers to entry, and how incumbent players are going to play given this huge menace. So I'd like to know hear your thoughts about it, because it seems going to be a very big movement in the next years. So how competition agencies are ready to deal with this big change that is coming up?
That's not easy to answer, I would say. Look, I mean, I think generally on new technologies that are very dynamic and that come into the market, of course, it presents a challenge. You know, we're just administrators, so I think we also have to recognize our own limits. So I think what's important in taking stock of new technologies is really get a sense of what Michael called the business story, the narrative around the merger. So, you know, if I think back, 10 years or whatever, when I think we were not well prepared for some of the tech mergers that were there, starting with Google, DoubleClick, and then later Facebook, WhatsApp, Facebook, Instagram, and so forth. And I don't want to opine on any specific of those mergers, but I think, given that not a single one of those was challenged, not one. Even though these are all companies in changing markets where you could easily, at least in retrospect, see, well, I mean, we were too backward looking in looking at those deals. Yeah, I mean, I think I'll use the Facebook, Instagram, which was not a Commission decision, but the UK made the decision, so I can blame them instead of ourselves. If you read the decision, it's about some photo app thing, and now you read it back and you think like, oh my God, it doesn't even realize sort of what actually the threat was. And to some extent, hey, if we don't understand it, we cannot prohibit it. So we have to look forward. And then I think we have to look at the internal documents of the companies and really understand if we see that a dominant tech company sees something as a threat, and that's why it purchases that company. If it's good enough for the company to spend 20 billion, then I think it should be good enough for us as an authority to worry about it.
Questions?
I would just add on that. I don't know that I agree with the premise that AI lowers barriers to entry. I think the challenge with enforcing AI is ensuring that that there is access. I'd be very concerned that the same dominant companies aren't dominating in AI as well.
So we don't have more questions. So I think I would like to thank you everyone here in the panel, as well as the audience. So thanks so much, Amanda, Michael, Hans e Letícia. O último anúncio aqui é que a gente tem o lançamento do livro de verticais, né? A Adriana e a Vivian, que foram uma das responsáveis, as coordenadoras. A gente tem aqui o pré-lançamento, né, Vivian e Adriana, do livro de fusões verticais. Várias das pessoas que estão aqui contribuíram com vários artigos muito bacanas. Então, a gente convida todos, acho que está já ali, né, Amanda e Vivian e Adriana. E a gente vai ter depois o lançamento oficial, mais para o final do mês. Novembro, né? Tem data já? Ainda não. Bom, obrigada a todos, todas. Foi um prazer aqui a gente ter essa ótima conversa com todos. Obrigada, gente. Até.